All right, so I'm about ready to.
Yeah, take it away, JR.
Are we on board? Okay, hi. Hi, everybody. Welcome to What's Up with Us, named by Neil Kalin. He also calls it Woo Woo. It's December 17th. And today's hosts are me, myself, and I, Ashley Peterson and Franz Farreau. Did I say Farreau correctly?
You did.
And today we also have a special guest, Mark Wilson, who's also on the screen here.
Hi, everybody.
Hey, Mark.
Hi, Mark.
So today's agenda, again, we just did the introduction. We're going to have a little interview here with Mark. If you spotted the e-news, it just came out yesterday. There was a interview with Mark on there. We're going to talk about this month's big event, the Women in Leasing Symposium that just happened. Hot topics with Ashley. Health and wellness issues. That's going to be led by Franz. And then the normal opportunities for involvement, input and suggestions, anything that you might want to enter in yourself. So first up, we have Mark Wilson. Oh, sorry. Look at these really awesome looking people.
All-star cast.
We look very official.
That's Ashley, Franz, and I.
We're missing Neil today. We have to mention that. We're so sad he's not here today.
Oh, yeah.
You're definitely missing Neil, but we'll try to forge ahead and honor. He's a great addition. By the way, if anybody doesn't know, Neil is one of the senior forms advisors, VPs of CAR. So he actually does a lot of the forms development for CAR. And then if you happen to be a real estate broker or agent and you do one of the CAR Zoom or whatever classes, oftentimes they're taught by Neil. So I like to razz Neil when I'm in one of his classes.
No, I actually had him as a speaker for the San Diego County Bar Association several years ago about car leases, I think it was. So
yeah, that was a great seminar. I remember that. That was several years ago.
That's right. Yeah.
Yeah, he's a great speaker. We're trying to have him at the Contra Costa bar up here soon. One of the neat things about the COVID crisis, or one of the only things maybe, is that we can have people from all over the state come as speakers locally because of Zoom, just like what we're doing here. So,
right.
Well, no further ado, we have Mark Wilson here. You've heard him chime in just a little bit. I want to do a little bit of an introduction for him. He's an attorney with Community Legal Advisors in the San Diego area. About 99% of the work that they do there relates to homeowners associations, either as general counsel or on the litigation side. So everything from actually attending the meetings, helping with decisions and collections, to disputes over architectural committee stuff. It's good to have you on, Mark. It really is. I get a lot of calls, people upset with their HOA. So I got a lot of questions for you right now, but maybe later. But
all right.
Yeah. So one last little tidbit is he went to undergrad at UCLA and he was an English major. So he's
Go Bruins.
Go Bruins. And he's got a lot of great opinions and things to share about literature. So if you're interested in either homeowners associations or in literature at all, stay tuned. There's a lot of good things to share here. So can you tell me, Mark, a little bit about, you're a brand new member of the real estate, our executive committee, correct?
Correct.
Tell me about some of the things you're hoping to do here with our group.
Well, I'm very excited about being a member of the XCOM, and I worked with Ashley several years ago, or actually just about a year ago. I worked with her for several years at the local bar association in San Diego County. And so I saw Ashley at work, both on our board and also working, at that time it was with the state bar. But I just saw the wonderful work she was doing and just the fact that you can reach so many attorneys in California with networking and the educational events, et cetera. So I'm extremely excited to be a part of it. Currently, I'm working on a social media work group and currently trying to get the word out about Facebook and LinkedIn and the Real Property Law Section's presence on both platforms, just another social media platform. So I'm drafting case alerts, monitoring new cases that come in that affect real property law, making them into bite-sized form and then sending them off so we can get them into either the e-news or put them on Facebook or other social media platforms. So in addition, I'm starting an HOA Common Interest Development PAC, or so basically it's a subcommittee that is hopefully going to have a large amount of expert HOA attorneys across the state. There are so many diverse aspects of the practice of HOA law and common interest development law, including some attorneys who focus on commercial associations. So there's commercial associations, residential associations, attorneys who represent either the owner or the board. There's attorneys who specialize in development, the MAP Act side of HOAs. So I think every attorney at some point has been affected by a case involving an HOA. So I just think it's important to have the section focus more, or at least have more of a focus in that area. So it's exciting.
So I want to share one little tidbit. I had a case where a client had cut down some trees, and the HOA thought they were in the common area. So you know what that means. That's like big deal, right? I mean, I can see you're already smiling like it's a big deal, right? But it happened to be that it was on my client's property, but it was in an easement for the HOA. So the HOA thought they were their trees, but they were ready to fine this guy like $300,000 for cutting down these trees. I mean, that's
wow.
Those are some expensive trees. What were they, Tory pines? Like, shoot.
Well, if you know anything about like tree litigation or cutting down trees in California, it's a big deal. So anyway, we'll talk about that sometime when we actually meet up in person, Mark. So,
hey, Mark, what inspired you to want to specialize in HOA law? I'm curious.
I didn't actually set out wanting to specialize. I had my own practice for a few years. I started out in real estate law with an attorney named Michael Spilger, who was an expert in essentially real estate transactions, and was with him for about 3.5 years. Started my own practice after that. And after a few years of practice, I decided to stop, take my shingle down and try to get hired with a law firm. And I met attorney Mark Guthues, who is the current principal of Community Legal Advisors, where I work now, based out of Oceanside, California. And I was sold. He was so passionate about HOA boards. And it's not just the practice of HOA law, it's the specialty of representing the HOAs themselves. And he just had a real passion about it, and I was sold. And just these are everyday people from all walks of life who volunteer their time to manage an association and try to make their community better. And with that, it's like these mini governments almost. And with any government, you have everything go on, the highs and lows of success.
Power trips.
Making mistakes. Not knowing what the heck they're doing when they get in there. And, they need help. They need, so we do trainings too, new boards that come in will come in and train them on, what their role is, about the Brown Act and, things like that. Because being on a board, there's a tendency with homeowners associations to try to, it's just not as formal, and it's more informal, but it is important to keep the formal aspects of a corporation, and not get too lax, because some owner, all it takes is an owner having an issue and filing a lawsuit, and you don't want to be on the wrong side of that. So sorry for my long-winded answer, but it was essentially Attorney Guthrie just inspiring me, and I just realized there's a definite niche there, and I've enjoyed it ever since.
Love that.
Yeah, we're really glad to have you on with the RPLS, by the way, and heading that up with your subcommittee with the CID stuff. So it's awesome. So tell me what you can tell me about 3182. That's that law that was recently passed and has to do with rental units in HOAs. And give me a little brief outline about the law and what you think.
Yeah, I understand the legislature had to do something. They've done several things, in fact, this past year, to address the housing issues in California, shortage of housing, and the real issues there, especially with the impact of COVID. And, so it's the legislature acting, trying to shore up housing, access to housing, a big hot button topic in HOA laws, short-term rentals. And it's still an issue, and rentals in general with HOAs, the impact that tenants have on the community, whether, in other words, this is an attempt to increase housing, address that shortage, and make HOAs, actually make it more concrete, the civil codes about what an association's governing documents, the provisions in the governing documents can do to prohibit leasing in an HOA.
Well, okay, so hold on a second. I'm going to interrupt you. So let's back it up a second. So the AB 3182 basically makes it mandatory for HOAs in California to allow units in their HOA to become rental units, right? And they can't limit the amount, right? A lot of them have like only 25% max or whatever, something like that. They reversed all that, erased that, correct?
Well, essentially what it is, there was never really a definition of what it is to prohibit the rental or leasing of a separate interest. Is it a rental cap where, you have a 30% limit on rent, 30% of the separate interests maximum can be rented out? Does that prohibit the rental or leasing of housing? And you could argue yes, for owners who are affected by that, say, 30% of the separate interests are rented. The remaining owners cannot rent out their separate interests. So in that effect, a provision like that would be grandfathered in according to section 4740. And it essentially only applied to amendments after January 1st, 2012. So, it didn't affect mainly new amendments and restatements to CC&Rs for the most part. Now the amendment does away with that limit. So it's any provision at any time in a recorded governing document, or rules for that matter, that prohibit the leasing or rental of a separate interest. It does not apply if it prohibits the rental or leasing. And what the legislature did was they added a new civil code, section 4741, that kind of helps to define what it is to prevent rentals or leases. And what they've done is they've kind of taken two of the favorite types of provisions HOAs use, whether it's limiting a rental term in the governing documents, or it's a rental cap. So what the new Civil Code 4741 does is it says, okay, nothing prevents an HOA from having a 25% rental cap, or having less than that. But they cannot go more than that. And if they, essentially it's defining what the limits are for HOAs. In addition, they have a provision in 4741 that says it's nothing's preventing an HOA from limiting rentals or leases to more than 30 days. So HOAs, now it's defined, hey, that's technically reasonable. So HOAs can have provisions. That doesn't mean it's prohibiting renting or leasing a separate interest. So those two things, along with the new section 4741, adds ADUs and junior ADUs, which is a big deal, because there are a lot of, especially in PUD associations, there are a lot of garage conversions to PUDs and things like that. So it's going to have a big effect, and you know, it's going to increase parking problems and issues at associations, because the local ordinances and rules for, say, Oceanside or other cities throughout California, they're addressing ADUs and JADUs, the juniors, and there's a limit. It cannot have a negative effect on parking. So associations can't really do anything to deal with the parking issue.
Does it restrict anything with regards to short-term rentals, Mark, or does it address short-term rentals at all? Or is that still something HOAs have the discretion to limit or not?
Well, basically what it does is it says essentially that it's reasonable to have a provision that restricts a rental term, that requires a rental term to be at least 30 days or more than 30 days. So with that said, there really isn't, it doesn't really address more than that as far as other restrictions you can do on short-term rentals. But you can from the way the law is written, limiting rentals to at least 30 days would be considered reasonable. We already had case law that said that, so it's not like this is extremely helpful in that sense. But you know, I think it's going to take some cases, you know, to go through and go on appeal and further flesh out these new laws. But
so speaking of litigation, it does seem like this new law will cause more litigation, because there'll be people asking for more clarity on, you know, what is blocking, unreasonable blocking of renting a unit, things like that. And so I think, right, don't you foresee an acceleration of HOA litigation over this?
I can see that. Yeah, I think there are a number of different issues, not to mention 4741 creates a cause of action for owners. So it's literally, what is it, $1,000? It can be up to $1,000 fine. Sorry. Yeah, per violation, $1,000 fine per violation of the law. So I think it expressly authorizes litigation. And you know, whenever you have something with, you know, a provision like that, where you can have, in addition to any other damages, violation amount, then you're going to get some litigation in there as well. So I think when it's all said and done, we're going to see an increased litigation regarding this.
So Neil snuck in and he just asked a question here. Neil didn't tell us he was sneaking in late, but
what is this, a ghost of Neil? I thought he was unavailable.
What's up, Neil?
So he's just messaging through the message board. I told him
he's on the chat.
Yeah.
He's on the chat.
So his question is, in Mark's experience, what percentage of HOAs restrict short-term rentals, and is such a restriction common or rare?
I would say that restrictions on short-term rentals are not rare. A lot of CCNRs do have provisions that restrict short-term rentals, primarily in condo associations, the governing documents for condos, CCNRs, for planned unit development type associations like townhomes and single-family residence. It's still popular to have such provisions, depending on where you live. I mean, if it's a coastal community, it's a hot button issue, and depending on whether there are a lot of, it's an association with a lot of absentee owners originally, and it planned for more of like vacation type homes, that can differ and maybe not have such short-term rental provisions, but it is fairly common to have short-term rental provisions, or just provisions that set a limit on rental terms, at least.
Have you found that it's been upheld with these, because I get a lot of short-term rental calls from clients and I've done a lot of presentations on that issue, but from an HOA perspective, I've noticed the fines have been like exponentially increased for violations, like something like $5,000 for just the first violation. Have you found that those have been pretty much upheld as reasonable, or are they like excessive, or what have you found?
I would say, depending on the situation, depending on the community. I mean, there are some communities with multi-million-dollar homes and, things like that. So, but I would say a $5,000 fine, it's for at least for initially, it's pretty high, but, you got to realize too that, these HOAs are trying to find teeth in their rules and be able to use something that actually will enforce the provision, because owners are going to do basically a valuation assessment, and hey, if I can rent my home out for short term and make all this money, it may be worth it if the fine is low. So
That's certainly the case in San Diego when it was Comic-Con. I mean, people would make thousands of dollars in just like 3 days, and so if their fine for their HOA was like $300, like, okay,
Right.
So I get that.
So I guess
So,
on a case by case basis, but to answer your question, it's to be seen. I haven't, at least hopefully somebody can correct me, but I haven't seen a case that came down at least on something that, would make it a close question about the reasonableness of the fine. So.
All
So
right,
I'm
Hans-
actually-
Hans has a
I-
question.
no, I was going to say, I am curious, what's stopping, if there's a 30-day rental restriction, and I've actually had clients who asked me this, what is stopping a homeowner from saying, okay, I'm going to have a 30-day lease, but you can break it without cost, and I'll refund you what you didn't pay, and I'll bring in a new tenant?
So you're
Alright.
saying on paper, it looks like a legitimate lease that is for 30 days, and that's not
Right.
And
They
Well,
just
yeah.
break the lease and then.
hey, if the board doesn't know about it, they're not going to know about it. But if the board finds out, they can, take action against a homeowner who is using, trying to do an end around the provision and regarding rental terms. So, but
Well,
no,
it's not usually the board that finds out. It's usually a nosy neighbor that doesn't like it. So then they're like, hey, I saw 4 people coming in and out of this house last week, so.
nosy neighbors are the board's friend. Let's put
Yeah.
it.
Okay, so everybody, we have limited time with Mark here. He's got a hearing he's got to go attend. So I want to bug you real quick, because there are 2 questions in my interview with you that I had that I just loved your answer. Okay. So this is a guy that loves literature. So if you like to read, he's somebody you can talk to quite a bit. There are 2 questions I had. The first one is what's a book or a couple of books that you say that absolutely everybody needs to read? There's like a couple books that everybody needs to read. What ones would you say?
That was a tough one. Actually, your question said, what one book? And then I couldn't just give one book, so I had to do 2. my first, and this is not in any order, would be A Farewell to Arms by Hemingway. I just fell in love with that book after I read it, and actually read that at UCLA when I went through my undergrad for my English degree. So love that book, love his writing. He's so, his writing is just to the point. And so, I mean, it's a real lesson for lawyers too, to minimize with your writing. So my second book would be Flow My Tears, The Policeman Said, from by Philip K. Dick, who I love. He's such a creative writer, and I'm kind of a science fiction nerd, to be honest. So not kind of.
So Philip K. Dick is a science fiction writer. He was American, and he passed away like in '89 or something like that, right? So he actually, all of his writings are kind of have become posthumously very popular. Is that accurate?
That is accurate, and a lot of movies made too after his books or short stories, and so it's interesting. I think the Truman Show, actually, I don't know if you remember that, but
Oh yeah.
I think that's based off of Time Out of Joint by Philip K. Dick. At least it's very similar. And there's also a Keanu Reeves movie. I'm blanking on the name, but it was like a semi-animated movie. What's the name of that again? Anyway, but
I
there
didn't
are
see that one.
a number of different other movies
Yeah.
based on his writings. I mean, he's very creative. So
All right. Well, you're a new member. We haven't been able to hang out with you for a weekend yet, but or do our what is that called, the retreat, Ash, when we go when we all hang out for 4 days together.
Yeah, our real property retreat. Yeah.
Yeah, we're really looking forward to it, Mark. And so thank you for joining us. Good luck on your hearing today.
thank you so much. Bye, guys.
Thanks, Mark.
Adios, bro.
All right. Take care.
Okay, next up. Oh, I forgot. That's a picture of Mark in graduating from UCLA. And then there he is. Sharp guy, huh? Look at that. All right. So Women in Leasing Symposium. We had JJ Sherman on last month, and she was just, wow, what a superstar, right? And then this is organized by our own Joanne Woodsum, who's a superstar. And I've attended this thing a few times, and it's just amazing. Wasn't able to go this time. Ash, did you have anything to share about this event?
Yeah, they did a really exceptional job this year. It was very cool because it was virtual, so a lot more people could attend. I know in the past it's always been up in San Francisco and the Bay Area, so for me it was really difficult to get up there usually for the conference. But I was really excited to be able to attend this one. It was nice that it was spread out over several days at lunchtime, so you could kind of just set that time aside. And the speakers were all really great, talked about very topical COVID issues with commercial leasing. So I thought they did a really great job, and I think we've gotten a lot of really good feedback from people who did attend. So I look forward to the one next year.
It's amazing. Every year she has a little different lineup, and yet the quality of speakers is just super strong.
Yeah.
Really good. All right. So next up. Oh, hot topic, Ashley M. Peterson.
Well, so Mark,
France.
yeah.
Hold on a second. France. What does the M in Ashley M. Peterson? Is it Maryland? Is it Maryland? Or is it May? Or is it Mary Ellen?
Is it May? I think it might be May.
Yeah, good job. I love JR's trivia facts about real property people.
All right. Good job, Franz. All right. What do we got here, Ash?
All right. So Mark was an English major. I was an art history major. So I picked a case this month that I thought was really interesting because it dealt in the art realm. So the Guelph treasure is actually, there's a picture of it there on the slide, or at least one of the pieces from the treasure, but it's a medieval gold and silver pieces that is valued around $250 million now. And in World War II, the Nazi governor of Prussia actually purchased this Guelph treasure from these Jewish art dealers and then ended up gifting the treasure to Hitler in 1934. So the men who are filing suit now, it's Alan Phillip, Gerald Steibel, and Jed Leiber. I think Jed Leiber is actually, he owns a famous recording studio in Hollywood. But they're all descendants of these Jewish art dealers, and they're trying to seek restitution of this treasure on the basis that it was sold to the Nazis, obviously during, the Holocaust era, and it was only sold for a fraction of its actual value, approximately about a third of its value at the time, and that basically it was a sham transaction and a taking. So they filed suit against the German Prussian Cultural Heritage Foundation, who's the actual current owner of the treasure. And the courts actually determined, so this was a suit that they filed originally in February of 2015 in district court in Washington, D.C., claiming, that this was this transaction was a sham and they needed to get the treasure back. So they filed it on the basis under the U.S. Foreign Sovereigns Immunity Act of 1976, which was really interesting. When I was reading through the case, I didn't know much about that, but it prohibits lawsuits against foreign countries in the United States unless the government is taking property in violation of international law. So the Jewish descendants are claiming that basically there was a violation of international law here. They prevailed in the district courts, and then on appeal, the appellate court also affirmed the lower court's decision to let them pursue this case. And so then the Germany and the Prussian Foundation filed writ of cert to the Supreme Court, trying to seek whether the property takings from German Jews were in violation of international law and therefore subject to this Foreign Sovereign Immunities Act, and two, whether the court can decline the jurisdiction granted to it under the Foreign Sovereign Immunities Act. So they just heard this case at the Supreme Court on December 7th, and so they're expecting to get a decision in June of next year as to whether this case can proceed in the United States or not. So it's really, really fascinating stuff, and I think it's very interesting. I don't know if anyone saw that movie Woman in Gold with Ryan Gosling like years ago. Obviously Ryan Gosling's, a heartthrob, but it was a great case because that was about a Gustav Klimt painting that was taken by the Nazis during the Holocaust, and the family sued for restitution of that painting, but they actually sued in Austria, not in the United States. So that's why this case is different and interesting as to whether it will be allowed to proceed or not. So I think if they are allowed to proceed, this will open up a lot of new opportunities for Jewish descendants to try to recover, artifacts from their families. So that's that case. I thought it was really interesting. And then
it's really chilling to think. So what is it? We're 70 years away from that World War II, and
yeah,
we're still trying to get things back to where they really should have been, and talking about that. And that's really chilling. It's amazing. I mean, look how beautiful those pieces are, and to think that they were basically stolen. It's an interesting issue.
Yeah, so interesting. So then these other two cases that I have here are kind of relevant to each other. So the first one I'll talk about is a very important landmark decision. That's the Roman Catholic Diocese of New York versus Cuomo. So this was a case by the churches filed against the governor of New York, claiming that his executive orders that were limiting occupancy in their church congregations to 10 or 25 people, and claiming that that was unconstitutional, a violation of the First Amendment and the Equal Protection Clause, and freedom of expression. So they were claiming that the houses of worship were basically singled out for harsher treatment under these rules, because there were other essential businesses that were allowed to operate that were, and that there was no equal treatment under the law with this ordinance. and that the church was taking every precaution required by the CDC, and they had no outbreaks of additional COVID cases in their church since they had reopened. So the court actually held in a landmark decision on November 25th that, the governor's emergency order didn't pass a strict scrutiny test and was not narrowly tailored to serve a compelling interest. So it was a violation of the Constitution. So that case has been a landmark case for this other case that was filed in California, which is the Harvest Rock Church versus Gavin Newsom. So that case has now been remanded back to the appellate court for rehearing based on this new decision that just came down. So really interesting to see that there's a lot of challenges to these governor orders and emergency ordinances, and claiming that they are basically violations of the Constitution, and that they're going too far in what they are doing. And there's really not a uniform or scientific basis for that. And in fact, in San Diego, we just had a case come down yesterday. A county judge was listening to a case that was filed by Pacers, a strip club here in San Diego, and they filed suit against the governor for, not allowing them to be open. And they also claim that they're a restaurant establishment, because we all know everyone goes for the wings, right, JR?
Very good.
But anyway, they actually won. This lower court judge yesterday just decided that they were allowed to be open, and there was no proof of the scientific basis behind closing restaurants that have been operating safely. And he also broadened that ruling to apply to all restaurants in San Diego County. So right now there's some confusion as to what's going to happen with restaurants in San Diego, but right now at least the police force and the sheriffs have said that they are not going to cite any more restaurants for opening based on this decision.
So in my hometown, I live in a small town called Danville. There's like 3 or 4 restaurants that refuse to close.
Mm-hmm.
The news, and one of the major restaurant guys in town, he's like, "Listen, I'm going bankrupt here. Like, this thing is killing me." I mean, literally, like, his house is in foreclosure, and he's like, we are in a state of emergency on our side too. Like, we provide a service for people. It's an amazing debate. I mean, I think it's
well, and especially if the restaurants are complying with all the CDC requirements, 6-foot distancing, wearing masks, or being outdoors. It's like they're trying to say, hey, we're doing everything possible, and we're agreeing to jump through your hoops, yet you're making us close down again. So it's a tough decision. I know many businesses here in San Diego are doing the same thing, where they're just defying the order completely because they're like, we have no other option other than declaring bankruptcy. So
right. The problem is there are local jurisdictions that are basically getting decisions in their favor to allow them to stay open, but the state law hasn't been superseded. So that's where the confusion comes from as to what enforcement they're going to use. And probably we wouldn't be having these problems if people had a mask mandate to begin with. So it's kind of a vicious circle. But yeah, there's a lot of confusion for sure. Sorry.
Yeah. Hi, Nancy.
our friend Nancy Goldstein. Hey, Nancy.
Nancy is our zealous, our ex-com member who's in charge of our webinars. So thank you, Nancy, for that.
No problems. I had to see what you guys were doing today for sure.
Yeah, glad to have
So
you.
far, so good.
All right, Ash, any last remarks?
Nope, I think that covers it. Just some quick summaries of some interesting cases that I thought were relevant. So
Great,
I can't
thank
wait
you.
to see what happens with the Germany case. And I did
Yeah.
see that movie. It was fabulous.
yeah, I agree. I thought it was really well done.
I love that history stuff, like all the artwork that was stolen by the Nazis, stored in the mountainside. I mean, there's all these stories about stuff like that. It's crazy.
Well, the great point in the movie I thought was when they basically they said, how can you prove that the painting actually even belonged to the family? When you see the painting and you see the great granddaughter who's bringing the action, I mean, it could have been painted of her.
Oh,
So-
wow.
That was pretty cool. Anyway, sorry, I'll be quiet.
It's all right. It's okay. So next up on the agenda, we have Franz Farreau talking about some health and wellness issues, Ashley and I and Franz are all big into health and wellness. It's a big part of who we are and how we are able to survive on a daily basis as attorneys. So
Yeah,
Franz,
yeah, we have to say, I'm super excited. JR and I have just formed a health and wellness committee for the real property section. Franz has been generous
Yeah.
enough to volunteer his time for that committee also. But I'm super excited because we're going to have several events all throughout next year, every month, that will be health and wellness focused. And I'll let Franz get into it more, but I'm just super excited. And if anybody else wants to get involved, they're more than welcome to email or let us know that you want to join the committee and help us plan some of these events, because I'm super excited about it.
or if you want to help organize a Zoom event that's health and wellness oriented, you have ideas, come share them with us. We'd love to hear from you. All right, Franz.
Yeah. Okay, so when I was sort of coming here, I'm like, I need to have something to talk about. So I decided that I would talk about health and wellness. And I also looked up, and apparently December is National Drinking and Driving Awareness Month, which brings up a really serious topic as far as the law is concerned, which is that lawyers really like to drink. This is a well-known fact. There was a study done by the Betty Ford Clinic in conjunction with the ABA in 2016, and they found that 20% of lawyers actually have a drinking problem, just based on the criteria. And if you just look at the amount and frequency of alcohol consumption, then over a third of lawyers have a drinking problem. And that's compared to 6% of the general population. So that means that it's a topic that we do need to talk about. And it also kind of leads into this idea of, why do lawyers drink more than the rest of the population, and what can we do to, resolve that issue? And so, JR, I was going to talk to you a little bit about your Dry January article. So the first obvious question is, what exactly is a Dry January?
Basically, after New Year's, I'm starting on the first day of January. I don't drink any alcohol whatsoever. I mean, unless it's like added to food or something. But and then I usually just I've done it. The first time I did it was over a month. I almost did two months. The second time last year I did a true month. So I just stay off any sort of alcoholic consumption whatsoever for the whole month.
Awesome. And how did that come about? Why? What do you get out of doing that?
I mean, I'll be honest. I went to a college where alcohol abuse was rampant. I mean, it was like basically we didn't care about what the sports scores were at this place. Like all the conversation had to do with alcohol, and so it kind of inbred a real unhealthy attitude, I feel, in me. And so I always wonder if I'm really healthy about alcohol or not. I mean, it's an inner dialogue that I have. And so I went to the doctor. Doctor recommended. He didn't advise me. He told me he does a Dry January every month, and he said it just lets me know that I'm in control. And so in my mind, there is a lot of gray area with alcohol. You talk to almost everybody. A lot of people have a glass of wine a night, but what happens when it comes 3 a night? Or how often are you actually drinking? And I know people that don't drink that often, but then they binge drink when they do. That's also unhealthy. So there's a lot of gray area. I think having a Dry January lets you kind of step back and really evaluate your consumption and whether it's healthy or not.
Awesome. I definitely agree. And I read your article, the article that you wrote, and I thought that it was insightful and helpful, and gave some good insights on why do a Dry January and what sort of impact that has. So I think the other thing that comes up in terms of this idea of a Dry January and also alcoholism in the law, at least as came up in this like Betty Ford ABA study, is that there is a very significant social component to drinking in the law. So I can say that I don't know how many law-related events I've been to where there hasn't been some sort of alcohol involved, whether it be wine or beer or something more than that. Um, and so my question for all three of, well, I guess for all three of us is, what are some actually dry social activities? So what are some things that in this dry January, perhaps not in COVID times, but like dry Januaries in post-COVID times, what are some sort of dry social activities that people can engage in as attorneys to connect without the need for alcohol?
I'll go first. I think joint walks or runs or any sort of activities. Like I went down to San Diego. Ashley took me, we went and did a workout. What was that place called? Barry's?
Yeah, we went to Barry's boot camp. I was impressed you wanted to do it.
So before our meet, I took an early flight in and we went to Barry's together. And then during that same weekend, I took walks with other attorneys in our group. And we went away from the alcohol and we went towards at least something that kind of got us out and breathing air and stuff like that. So that's my answer.
We always, and every time we would have real property executive committee meetings anywhere, we would always have a group that would meet at the gym in the mornings before our meetings or go for a run on days that we had off. And that was such a great thing. I mean, I loved that we would motivate each other to be healthy and do those things. And there's just so many more opportunities to do, yoga online now, have online meditations. There's apps out there like the Calm app I use, and that just gives you daily reminders about meditations and different sleep stories and ways to just be calmer and handle the anxiety. So for me, keeping my stress levels is huge, and in recovering from a major health issue this last year. So just keeping anxiety low, stress low in a very high stress job that we all have is a difficult challenge, but it's definitely worth doing because it has much better long-term effects on our health and wellness and mental being.
Yeah. And for me, I think two things. One, social activity I enjoy is just playing video games, which is great and doesn't involve alcohol. And I mean, I'll just speak for myself. I don't really drink all that much at all. And so I just remember that, and I also am a ballroom dancer, so I would go ballroom dancing every Friday night where alcohol at that event was not allowed. And so that's an evening activity where I've actually connected with a lot of people many of whom have become really close friends, who, that was just a really great way of connecting, just like going out, dancing, talking to people, having good food, and not drinking. So I think all of those are really good options for, dry social activities that can be really, really helpful to connecting and also, connecting on a more personal level. So one of the things that I find with alcohol is that sometimes the conversation happens and then the next morning it's a little bit fuzzy and people were not fully present for the conversation because they were drinking. And so a lot of times when I have activities where I'm not drinking, then the experience is more alive for me as something that really happened and I was fully present for.
It's such a hard thing though. I mean, the social stigma of it, like you said, I mean, most events can, it feels uncomfortable to not drink, or if you're in a room with people you don't know, you want to drink to take off that edge, so it's really, it's a challenge and you have to really force yourself to have that discipline, or just order a club soda with lime instead of, a vodka soda. So,
Yeah.
So when we're holding events for CLA, for example, we're not going to tell everybody that there's no bar there because we're worried. We want it to be a well-attended event. Say there's going to be a bar there, there'll be bar tickets and everything like that. But certainly I know for a fact that there's people that are there that make a choice not to drink during the event. But I mean, basically I don't foresee us having a true just like hangout event without, I mean, unless we decide to have like a sit-in, I don't know.
And I think the other thing that's also true about the legal profession, which was also in the ABA, is that you know, a very high percentage of lawyers are also introverts. And so the concept or the idea of sort of interacting with people that they don't know, or just being in a social situation, can sometimes be really draining. And so I think that alcohol can certainly help with overcoming that draining aspect for somebody who is introverted. So I think there's a lot of issues there. I don't know if Neil wants to contribute something to his idea of dry or no drinking.
Neil doesn't drink though. He
Yeah.
actually he's completely dry. He doesn't drink.
Yeah.
I
Oh,
tried,
that's interesting. I did not
I
know
tried
that.
to hand him a glass of wine one time. He's like,
Yeah, in Vegas, he didn't drink, which was very good discipline.
Yeah. Well,
Neil says he met his wife through dancing too. That's cool. We gotta admit Neil here so we can talk. Micah, can you add it?
I think
yeah.
he's choosing not to talk.
Yeah.
He either is choosing not to talk, or I think he might be busy or doing multitasking or something. But yes, that is absolutely, dancing is a really good thing to do. I cannot overestimate or overemphasize how much I think dancing is a good, fun social activity that everybody can benefit from.
So we should have a
Um,
dancing event.
We totally should have a dancing
Dancing
event.
event. There you go.
That would be
I
so
would be
fun.
there in a second.
We could add that to our health and wellness committee events. We'll have a online dancing.
Well, not so much because it's going to end up being pole dancing or something.
No, it wouldn't
No.
be pole dancing, Nancy.
Well, because remotely it's kind of tough, you know.
Oh,
Yeah, it's really hard to do that.
Like that, JR, huh?
no, I just think it's funny you said that. I mean, like, that's why I love this group is you can actually say things like that. You know, it's
Well, it's certainly lively. They say nobody said anything, but for many years the bar had the other bar because there is such a high rate of alcoholism amongst attorneys, and a lot of the MCLE that we do, has to do with stress relief, for example, and drinking is very related. And attorneys are up there in the top 3 stress professions. So I think that's why alcohol use is so heavy, whether or not it's a social event or not. So I think it's great that we should incorporate something in that vein. Into this.
Just so you know,
It's really, really needed.
there still is the other bar. It's actually an organization that counselors for people that have substance abuse problems. Greg Dorst and David Mann are 2 of the people that are counselors there. And then the state bar has a confidential program as well. It's escaping me, about alcohol and substance abuse problems that you can call in, and you get free counseling for a certain degree.
Oh, is it the lawyer assistance program or something like that?
LAP, that's it. Yeah.
Yeah.
Well, I think before the split, it was actually done through the other bar. I'm not positive, but we used to do some programming together with them whenever we were trying to get our special MCLA credits and the competency area.
So Franz, we only have a couple of minutes left. Do you want to wrap up with the few other things of the CLA January challenge? We can't forget about that.
Yeah, so there is going to be a CLA January challenge that Tara apparently put together, and it's going to be on Facebook. So if you join the CLA challenge Facebook group, then we will, and I actually don't have the email up, but once I'm not talking, I can actually find her email and then link everybody, just put a link in the chat to the activity. And basically there'll be different challenges. They'll be related to different things. Some of them will be mindfulness related. Some of them will be health related. Some of them will be food related, and just, checking off the challenges that you've completed, just as a way to, once again, check in and recognize how you are in tune with yourself and your health and wellness in the legal profession and also in the new year.
Right. Well, I'm excited about January for a lot of reasons. One of the reasons is that it helps me lose a little weight for my eating a ton for Christmas when I get the dryness. So that's another reason I kind of like it. All right, we're gonna try to wrap things up here. So in the real property law section, we have all these subcommittees, which we're always looking for more participation of people. If you have an area of law that you like to specialize in, please contact Marie Wood. Her email address is right down there. I think there's a link from Neil Kalin in there for the health and wellness thing that you can click on that. And we have two new subcommittees, Construction and Homeowners Association, which relates to Mark Wilson. And if you ever want to contact either Ashley, Franz, Neil, or myself, we're glad to hear from you. We'd like to hear your ideas about this show. If you want to be interviewed on the e-news, let us know. We'll do that. We're excited to hear from you. And then next show, January 21st, be there or be square. Bring your own boxed lunch.
I like that Neil put box lunch on there.
Yeah, I just took that from him. So anyway, thank you all, everybody. We had a great time. Mark Wilson, special guest, chiming in, Nancy Goldstein, Franz Farrow, and Ashley M. May Peterson.
Thanks, JR. Today was fun. This was good.
Thank you.
Awesome.
I think we're
Okay,
gonna
bye, guys.
sign off here.